everybody, welcome to my channel. My name is Rachel. If you're new here, hi, welcome. I film about book reviews, movie reviews, history, documentaries, legal matters and related stuff. In this video, I shall be giving you steps that you should take before suing that annoying person to court. Yeah, I said what I said. I'm qualified to give you these tips because I'm a lawyer, duly called to the Nigerian bar, and I've been in practice for okay. So guys, without further ado, let's dive right into the video. Welcome back, guys. Now, there's this Latin maxim that goes ubi jus ibi remedium. Not to worry, I'll say it in English. Where there is a wrong, there should be a remedy. Now, before suing that someone to court, you have to be sure that you were actually wronged or cheated and that you did not, in fact, condone the wrong done to you. Okay, what do I mean? For instance, you have a piece of land and a stranger goes onto that piece of land and starts building. The person lays a foundation, you kept quiet. No, in fact, the person started clearing the grasses, you kept quiet. The person lays a foundation, you kept quiet, you folded your arms. The person starts building, you keep quiet. And then finally the person completes the building. Oh, that's when you wake up and then you want to sue the person. Good luck to you. Step number 2, be sure that you have concrete evidence. Yes, you must understand that the judge before whom you're appearing is human and he has a mind of his own, which can be convinced. In Nigeria, our legal system is not inquisitorial as we have it in the United States. Nigeria runs an adversarial legal system where the court only works with what is laid before it. The court will never investigate your matter for you. The court will never go on a frolic of its own to go and gather evidence for you. The court can only work with what you bring before it. Now that's why we have burden of proof, standard of proof, the symbol of justice. You can, if you remember, she's holding a scale, okay? The scale is meant to measure each evidence. So it is important that during your business negotiations or your troublesome marriage, if it's a divorce matter, that you keep every important document, that you keep your emails, your texts, your photos, your documents, your bank tellers, keep your account statement, keep your credit and debit alerts, keep your device. Step number 3, get yourself a good lawyer. Now, it is no doubt that there are fake lawyers looking around. Yes, there are fake lawyers. Okay, get yourself a good lawyer. Make sure your lawyer is giving priority to your case. Be sensitive enough to know when your lawyer has been compromised, especially when the other party is a very influential person in the society. Step number 4, explore alternative dispute resolution. This cannot be overemphasized. It does not hurt to try settlement talks. Dear litigant, I know that you are furious. I know you may have been duped or cheated or even taken advantage of, but I got you. Calm down. Could you take a deep breath and think of the many possibilities of alternative dispute resolution? Believe me, ADR has lots of advantages. It is faster. Your matter could linger in court for decades. For those who choose to go for litigation. Your matter may linger in court for decades. But ADR is the exact opposite. It is faster. It is cost effective. If you decide to go to court, just bear in mind that for the next 2 years, 3 years, 5 years, 10 years, depending on the nature of your case, the matter may be in court. And for that period of time, you must pay your lawyer and you must provide appearance fee. Your lawyer is not gonna go to court on his own patrol. No, you have to pay appearance fee. Now, if the matter lasts for 5 years, and let's say on an average, the matter comes up twice every month, in addition to other professional fees you may have paid your lawyers, you have to provide appearance fee for every day the lawyer goes to court. And let's say he goes to court twice every month for 1 year. Well, okay, let's leave out the vacation period, because sometimes courts do go on vacation. But let's say on an average of, let's say, 8 months, your matter comes up twice every month for 5 years. Do the calculation and decide for yourself. ADR gives room for continuation of business relationships in the future, or continuation of any other relationship that was the status quo in the future. Nobody is sentenced. No damages are awarded against anybody. Nobody's property is confiscated or sold in the name of execution. Nobody's account was frozen in the name of any garnishee order. Mr. A and B simply reached a compromise, and Mr. A and B went home happy. Voila! Yay! There are tons of advantages, tons of it. Even privacy, because in open court, you have to wash your dirty linen. But when it comes to alternative dispute resolution, it's just you, the other party, and then the middleman. Just the three of you. And then your lawyer, just there to guide you. ADR comes in different forms, depending on which one you want. We have mediation, we have arbitration, we have conciliation, tons of ADR options. I'd like to give these forms of ADR short explanations. Okay, I mentioned mediation first. Now, in mediation, an impartial person called the mediator tries to help parties reach a mutually acceptable resolve. He does not decide for the parties, but helps them communicate, and then he leaves the entire decision to the parties. Mediation is particularly important where the parties have a relationship they want to preserve. This is suitable for business relationship, banker-customer relationship, etc. In arbitration, a neutral person called the arbitrator hears arguments and analyzes evidence from each side, and then decides the outcome of the dispute. It is less formal than a trial, and the rules of evidence are often more relaxed. It is appropriate in cases where the parties want a neutral person. They just want another person basically to look at their evidence and just decide for them. These are just the two most popular forms of alternative dispute resolution. We still have tons of others, but these are just two basic types of ADR, aspects of ADR. Now, it may interest you to know that in Lagos State, ADR has been taken to another level. Even if you're so furious that you really want to go to court, your lawyer has to involve in talks with the defendant. There's something called pre-action bundle. Your lawyer has to first write to the defendant, giving him or her a period, or giving it, in the case of a company, giving the defendant a period of time to respond or do something about the dispute. If your lawyer does not take this very crucial step, he cannot even be heard in court unless he's able to give evidence that the other party, that he in fact took steps, the other party frustrated his efforts. Now, even if you succeed in going to court and you are happy, yeah, you're going to deal with this person, the court itself, especially in Lagos State, would refer you to compulsory mediation at the Lagos Multi-Law Courthouse before the Honorable Court sets down your matter for proper trial. So, dear litigants, either ways, you're stuck. You just have to explore ADR. So there you have it, guys. We've come to the end of this video. If you enjoyed this video, kindly give it a thumbs up, share. If you haven't subscribed, please subscribe, and after subscribing, remember to click the notification bell below to get you notified of my other videos. I'll catch you in my next video. Bye.